The process of discovery in civil litigation is governed by the Federal Rules of Civil Procedure. Its fundamental purpose is twofold: to facilitate the truth-seeking process so that cases can be decided on their merits, and to ensure efficient case management throughout the litigation timeline. The entire framework for modern discovery is anchored by Federal Rule of Civil Procedure 26. This rule serves as the cornerstone, setting the stage for everything that follows. Rule 26 establishes that the scope of discovery is intentionally broad, allowing parties to obtain information relevant to any non-privileged matter pertinent to any claim or defense. However, this broad reach is not unlimited. The rule immediately introduces critical boundaries, governing what information is discoverable, what must be disclosed automatically, and what information remains protected from inquiry. Understanding Rule 26 is essential, as it dictates the parameters for all subsequent discovery activities, including scope, mandatory disclosures, and the assertion of privileges. Now we turn our attention specifically to the scope of discovery, detailed in Federal Rule of Civil Procedure 26, subsection B, paragraph 1. This section establishes a crucial two-pronged test for discoverability. First, the information sought must relate to any non-privileged matter. Second, it must be relevant to any party's claim or defense in the case. If information fails either prong, it is generally outside the scope. However, the rule adds a vital modern limitation: proportionality. Even if relevant and non-privileged, discovery must be proportional to the needs of the case. Courts weigh several factors when assessing proportionality. These include the importance of the issues at stake, the amount in controversy, the parties' relative resources, each party's access to the information, and the party's ability to obtain the information through other means. We will visualize this balance shortly. While scope defines what information can potentially be sought, the rules also impose duties to exchange certain foundational facts automatically, without waiting for any formal request. This is governed by Federal Rule of Civil Procedure 26, subsection A, paragraph 1, detailing initial disclosures. These disclosures are mandatory and must occur early in the litigation timeline. There are 4 core categories required. First, the initial identification of individuals likely to have discoverable information supporting or refuting claims or defenses. Second, copies or descriptions of all documents, electronically stored information, and tangible things that support those claims or defenses. Third, a computation of each category of damages claimed and the relevant supporting documents. Finally, parties must disclose any relevant insurance agreements that may cover all or part of the judgment. These 4 elements form the bedrock of early case understanding. However, even though much is mandatory, we must now note that certain information remains explicitly protected from disclosure. Building upon those mandatory initial disclosures, we now turn to a specialized area requiring even greater rigor: expert discovery, governed by Federal Rule of Civil Procedure 26, subsection A, paragraph 2. This rule creates a critical distinction between 2 types of experts retained in a case. First, we have consulting experts, those retained solely to advise counsel. Their identity and opinions are generally shielded from discovery, often protected by work product principles. Second, and far more relevant for disclosure, are testifying experts, those whose opinions will actually be presented at trial. For testifying experts, the disclosure requirements are rigorous. The party must provide a detailed written report prepared and signed by the expert. This report must include the expert's full qualifications, a list of all publications authored in the past 10 years, their compensation for the study and testimony in the case, and crucially, a comprehensive summary of the facts or data considered, and the specific opinions to be offered, along with the reasoning and basis supporting those opinions. This detailed exchange usually occurs on a specific schedule, often after initial fact discovery is complete, as illustrated on the timeline. Having examined what must be disclosed, we now turn to the crucial counterpoint: information that is protected from discovery. The two pillars supporting this protection are the attorney-client privilege and the work product doctrine. First, the attorney-client privilege protects confidential communications made between an attorney and a client for the purpose of seeking or rendering legal advice. This is the oldest privilege known to common law. Next, we address the work product doctrine, codified in Rule 26, subsection B, paragraph 3. This doctrine shields materials prepared in anticipation of litigation or for trial. It is not absolute, however, and is divided into two categories. Opinion work product, which includes the mental impressions, conclusions, opinions, or legal theories of an attorney or other representative, enjoys nearly absolute protection. Fact work product, which consists of tangible materials reflecting the attorney's investigation, receives only qualified protection. Fact work product can be overcome if the requesting party demonstrates both a substantial need for the materials and an undue hardship in obtaining the equivalent information by other means. The Supreme Court firmly established these principles in the landmark case, Hickman v. Taylor. We have covered information that is absolutely protected by privilege or doctrine. Now, let us address discovery that is relevant but still problematic due to its scope or intrusiveness. Even if information meets the relevant standard, the court retains power under Federal Rule of Civil Procedure 26, subsection B, paragraph 2, to limit the frequency or extent of discovery. If it is shown to be unduly cumulative, obtainable from another more convenient source, or if the burden outweighs its likely benefit. The primary tool for managing this is the protective order, governed by Rule 26, subsection C. To obtain a protective order, the moving party must demonstrate good cause. Common grounds for issuance include preventing annoyance, embarrassment, oppression, or undue burden or expense. Critically, courts frequently issue these orders to safeguard proprietary information, such as trade secrets, or highly sensitive personal data. The shield icon visually represents this judicial intervention to balance the need for information against the need for protection. Even when discovery is sought, parties must respond timely and in writing to all requests. If you cannot provide the requested information fully, you must state specific, particularized objections for every withheld item. Simply refusing is not an option. Crucially, when withholding documents based on attorney-client privilege or the work product doctrine, you must prepare a privilege log. This log serves as a detailed accounting to the opposing party and the court. For every withheld document, the log must identify the nature of the document, its author, the recipient, and the specific privilege you are asserting. This documentation is mandatory under the rules. However, the log itself must be crafted carefully. It cannot reveal the substance of the privileged communication or document. The goal is transparency regarding what is withheld and why, without compromising the very protection you claim. We have covered how to respond to discovery requests, including objections and privilege logs. But what happens when parties disagree on the sufficiency of those responses, or outright refuse to comply? This brings us to enforcement under Federal Rule of Civil Procedure 37. Before seeking judicial intervention, Rule 37 mandates a crucial first step: the meet and confer requirement. Parties must genuinely attempt to resolve the dispute without court involvement. If this informal process fails, the aggrieved party may file a motion to compel discovery responses under Rule 37A. This motion asks the judge to issue an order forcing compliance. The real teeth of the rule appear when a party flagrantly ignores a court order compelling discovery. Under Rule 37(b), the court has broad discretion to impose severe sanctions. These can include striking pleadings entirely, establishing certain facts as true against the disobedient party, precluding evidence, or in the most extreme cases, entering a default judgment. Remember, these powerful sanctions are not primarily punitive. They serve as powerful deterrents to ensure the integrity and efficiency of the entire discovery process.